Once again, welcome to the Law Professor channel. In this presentation, we shall be looking at dissolution of marriage again, but in this regard, we are looking at the elements of irretrievable breakdown of marriage, statutory marriage, of course, with regards to non-compliance with the decree of restitution of conjugal rights, failure to comply by the respondent with the decree of restitution of conjugal rights under the Matrimonial Causes Act 1970 of Nigeria. And don't forget what we had discussed in earlier presentations about dissolution of marriage, about the major elements, and we had established the fact that all these facts in section 15 are the various ways that you can prove that the marriage has broken down irretrievably. And in this presentation, which is going to be focusing on failure to comply with the decree of restitution of conjugal rights, we shall briefly look at what the law expects with regards to this. Now, the Matrimonial Causes Act in section 15(2)(g) provides for the dissolution of marriage on the grounds that the other party to the marriage has, for a continuous period of not less than 1 year, failed to comply with a decree of restitution of conjugal rights made under this act, that's under the Matrimonial Causes Act of Nigeria. So if the party that has brought the petition establishes this, then the marriage will be held to have broken down irretrievably. Don't forget the critical points that we all have identified in that slide. You establish that for a period of not less than 1 year, this other party, the respondent, did not comply with a decree, that is a court order, that it should restore conjugal rights, cohabitation with the petitioner. So that presupposes or the fact that there has been a court order regarding a statutory marriage, a court order under the Matrimonial Causes Act, that respondent should restore conjugal relations, and the person has failed for a period of 1 year to do that. If the person restores conjugal rights, receives the petitioner, for instance, into the home, as an example, even for a month, and then sends the person packing again, that person would have complied with the court order for restitution of conjugal rights. So it's quite a technical point. It's quite a technical point. So that is the idea behind this decree. Don't forget that we said the order must have been made with respect to a statutory marriage, because the Matrimonial Causes Act relates only to statutory marriage. And having said that, that is just essentially what that provision is about. So in looking at any question or any issue regarding this aspect of the Matrimonial Causes Act, you are looking at the timeline. How long has the decree for restitution of conjugal rights, how long has it been given? And has there been a request and a refusal to obey that court order? If there has been any compliance which is later, disrupted, you cannot bring a petition under this subsection. You may have to look at other subsections of the Matrimonial Causes Act to effect the petition. In the next presentation, we shall be looking at another aspect of section 15 of the Matrimonial Causes Act with regards to the irretrievable breakdown of marriage. Once again, don't forget to like, share, and subscribe to this video.